Hello, everyone. Thank you for being here today. And sorry, I'm not, well, online with you because I'm giving a class right now. I'm an invited assistant professor at the Faculty of Human Sciences of the Catholic University of Portugal. And today I will talk about the social networks, social media, and the author's rights law of the European Union. With the growing technological and digital developments that we have been experiencing in recent decades, new questions have also arisen about the legal use of works created by third parties, given their trivialization in digital media. Nowadays, unless the person in question is not a user of social networks and social media, situations in which third-party works are not shared and used, such as news, videos, music, images, are completely rare. First of all, we must have into consideration that all texts, images, and videos have at least one author. The author is seen by the law as the work's intellectual creator, and the work is protected since its creation, so you don't need to do any registration. By two specific rights, the moral rights and the economic rights. If the use you want to make of a work created by a third party goes beyond the direct buy of the work and enjoy it in a private context, you would have to ask for the author's permission, and depending on the context, also from other rights holders, and or even pay them a compensation. However, there are exceptions to that, like the work being under a license that facilitates the use, like royalty-free or a Creative Commons license. The work being in the public domain also, or the use being within a free use, fair use, or fair dealing policy. Though if the work that you want to use is not within any of these scenarios, you had a lot to consider, especially before the implementation of the European Directive of the Digital Single Market, since the European Union legislation didn't contemplate this new scenario, and this new directive just was implemented in 2019. So some of the most banal uses related to the social media and social networks were not technically legal, like sharing a text or an image, especially when it was made without the author's identification and or without being the author, the one who published the work digitally in public mode. Still, these forms of use became so normalized by society that the law can't do anything about these illegal cases or illegal uses unless the author or their representative could identify who was the one who started the illegal divulgation and give viable proofs of that. Legally, besides works in public domain and with licenses of facilitated uses, everyone can use, for example, quotes and direct sharing of content created and published by the author or their representative. But what about uses that you can do in social media and social network specifically? You can do some derivative works with the purpose of critique, to analyze or review, to do parody, pastiche, or caricature alike, for example, fan art, memes, criticize or analyze a film, a paper, an article, or other kind of texts, or even images and audiovisual works. Although before the directive of the European Union about the digital single market, most of these practices were already banalized by users. There was some discussion around uses that challenged the economic and semiotic interests of the original creator, even though the majority of fan art even the one commercially exploited, didn't have a relevant economic return in a way that damaged the main work. So also the lack of identification of the original work normally is completely developed in cases of well-known works like, for example, the Harry Potter franchise, or even a Disney Lion King, for example. But not in cases of most underground author, because it can easily be seen as plagiarism. This directive came also to clarify this question. Fan art, and depending on what it is, can be integrated into parody or caricature, like comic reinterpretation, or even pastiche, that is something, well, it imitates the style of an artist or work, but you can't confuse it with plagiarism, okay? That is an integral copy of the work. It has to be an original directive work to be legal. In the case of memes, for example, you should just be aware if you are not damaging the honor or of the represented person, of the original author of the work, or even the work, and if you are not publishing personal content against her or his will, okay, because that is illegal. In conclusion, what is important to have in mind when we use works created by others outside of the private sphere is if you enjoy them as a use or as a creator. As a user, the responsibility of the legal use and correct identification of the work and its representative author is from the ones who created the derivative work and the ones who allowed for the content to be disseminated in their online space, like the platforms or websites or web pages. If your use is included in these scenarios, the use is considered legal, so it is okay. However, if you are a creator that uses in their projects works created by others, or someone who disseminates a work that was not created well by you, or you hold the rights to exploit it, you have to carefully analyze the type of use you want to do. As it was possible to perceive, although the majority of the simple daily uses of works not created by us, like sharing content through social media and social networks, are considered legal. As a creator, the normal legal process is complex. You need to acquire a lot of knowledge and experience to know if your derivative work is legal or not. And even if it is legal, you can still be accused of improper use of the work, like not being considered a parody or a pastiche, for example. This means you need that kind of knowledge to protect yourself legally, since you can't claim that you don't know the law. No, so it seems crucial during a time where digital technologies are evolving increasingly and faster to rethink the law and its traditional methods, which are showing difficulties in keeping up with the evolution of society. We will continue to research and update all the information related to the topic in order to inform and alert all those interested in the importance of adapting the law to their society, and also to prevent users and creators of using improperly works created by others most of the time without knowing that are doing that illegally. So, well, thank you very much. I hope, well, you liked the topic, and once more, sorry for not being present. I have here my contact if you want to contact me and talk about this theme. Well, feel free to do so. So, thank you.